Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2, Jefferson County, Texas. My name is Judge Terrence Holmes. I'm the presiding judge here in this court. This morning, you were asked to come to court for what we call arraignment. What the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what options you have regarding your case. Now, the case that you have in this court is classified as a misdemeanor case. Criminal cases falls into one of two categories. It will either be classified as a felony or a misdemeanor. Your felony cases are normally referred to as your more serious type cases, and your misdemeanor cases are normally referred to as your petty offense. Now, that does not mean that a misdemeanor case is not serious. Now, for your felony cases, you have cases such as murders. It could be a capital murder. It could be a manslaughter case. You have aggravated robberies. You have burglaries of habitations, burglaries of buildings, aggravated assaults on police officers, intoxicated manslaughter type cases. You have drug cases. So you have a variety of what we call felony cases. Now, your misdemeanor cases, you may have a resisting arrest, evading detention, possession of marijuana. You may have a failure to identify, driving while intoxicated first, or driving while intoxicated second, or driving while intoxicated case with a alcohol concentration level of 0.15 or more. Or it could be a false report. It can be an assault, or it can be an assault, family violence. It could be a theft case. And so the difference between your felony cases and the misdemeanor cases, not only are the different types of cases, but also the major difference is the range of punishment. For a felony case, for example, for all felony cases, you could be sent, your punishment can entail a person being sent to the state penitentiary or to the state jail. Now, for example, for a capital murder case, the punishment can either be life or death. For a first-degree felony case, the punishment can be 5 to 99 years to life, a fine up to $10,000. For a second-degree felony, which is below a first-degree felony, the range of punishment can be anywhere from 2 years to 20 years in the state penitentiary, fine up to $10,000. For a third-degree felony, which is below the second, the range of punishment can be anywhere from 2 years to 10 years in the state penitentiary, a fine up to $10,000. And for a state jail felony, which is the lowest felony, the range of punishment can be anywhere from 6 months to 2 years in the state jail, a fine up to $10,000. Now, for the misdemeanor cases, they fall into one of three categories. It could be a Class A, a Class B, or Class C. Class A is your highest type misdemeanor. Class B is next, and then the Class C. Now, your Class C misdemeanors, a person can't be sent, the punishment does not entail jail time. It's fine only. A person will get a fine plus court costs. It will be a fine only, no jail time involved in that. Now, the type cases that we handle in this court are Class A and Class B misdemeanors. A person punishment can entail jail time to the county jail. Now, however, when Class C cases are appealed, now your Class C cases are your cases in your JP court or your city court or the municipal court. When they are appealed, then they come up to us, but it is still classified as a Class C, which means it's fine only. Now, for a Class A misdemeanor, the range of punishment is confinement in the county jail for a term not to exceed 1 year, and a fine up to $4,000, or you could be given both such fine and confinement. So it's 0 days or all the way on up to 365 days or anywhere in between. Fine $0 all the way up to $4,000 or anywhere in between, or you could be given both such fine and confinement. Now, for a Class B misdemeanor, the range of punishment is anywhere from 0 days to 180 days confinement in the county jail, which is 6 months, or anywhere in between. For a fine from $0 to $2,000 or anywhere in between, or you could be given both such fine and confinement. Now, you may qualify for probation. Now, probation basically means you don't go to jail. You're serving your punishment in the community. That's why they call it community supervision. And there are two types of probation that you can get or that you may get. One type is called adjudicated probation, and we normally refer to it as regular probation. And the other type is called unadjudicated probation. We normally refer to that as deferred adjudicated probation. Now, the difference between the two. With the adjudicated probation, it does result in a conviction on your record day one once you get on probation. However, there is something that is called judicial clemency, whereby the court has the authority to set aside your conviction, and if that happens, you will no longer have a conviction. Now, the way it works with the judicial clemency, you have to, one, successfully complete the probationary period. Two, the probation has to expire. You cannot have any more time left on the probation. Three, you have to be successfully discharged, meaning you have to be successfully let off the probation by the court. And if those things happen, then the court can allow you to come back in the court to withdraw your plea of either guilty or no contest. And if that happens, any complaint, information, or affidavit that has been filed against you will be dismissed. And obviously, once it's dismissed, then the offense that you have, that you was on probation for, you will no longer, once it's dismissed, you'll be able to truthfully say that you were not convicted of this offense because the court will set that offense aside, okay? Or set that conviction aside. And if that happens, now, if you get a subsequent conviction, another conviction later on, then the case can be revived, resurrected, or brought back up and could be used against you. If you try to get a license with CPS, they could deny giving you a license, or if you have a license, they can revoke or suspend your license. With the deferred adjudicated probation, it does not result in a conviction on your record. And if you successfully complete it, you may get an expunction. What an expunction, not an expunction, you may get a non-disclosure. And what a non-disclosure is basically means that the court, we cannot disclose to the general public that you were on deferred adjudication for that offense. However, if you violate the terms and condition of your deferred probation, then the district attorney, which is the state, can file a motion to revoke your probation, meaning to kick you off probation. And if that happens, a warrant could be issued for your arrest, you'll be arrested. However, you'll be entitled for a hearing. And if the court determines at the hearing that you have violated any one of the conditions of your probation, the court can revoke your probation. Now, if your probation is revoked, you may get a conviction. If you get a conviction, then that simply means that you cannot get a non-disclosure. Your case will not be dismissed. The forms that have been passed out to you is titled judge's explanation of rights to defendants without an attorney. Now, as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number three, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of that document, it states defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you'll put your initials on the first line to the left. If you have already hired an attorney, then you'll put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you will put your initials on the third line to the left. If you have already been a court-appointed, if you have already been appointed a counsel, then you will put your initials on the line to the left, the fourth line to the left, and the name of the attorney on the line to the right. However, if your choice is, I want to waive my right to an attorney and represent myself, then you'll put your initials on the fifth line to the left. Now, once you finish initialing one of the 5 lines, you will sign at the bottom where it says defendant, and you will place today's date, June 8th of 2021. Now, for those of you who are waiving your right to an attorney and representing yourself, you would have to read and sign the next document that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 8th day of June, 2021, by the County Court at Law Number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. If that's your choice, you will sign where it says defendant and you will place today's date, June 8th of 2021. Now, you also have other rights. You have a right to have a trial by jury. Where those young ladies are sitting, we call that the jury box. And 6 citizens from Jefferson County will be selected as jurors in your case. They will decide whether or not you are guilty or innocent after listening to all the evidence. You also have a right to waive or give up that right to have a jury trial. And by doing so, your case will come before the judge or the court. And you can have a trial before the court. We call that a bench trial, or you could enter a plea of either guilty or no contest before the court. You also have a right to have witnesses that come to court in your case. Witnesses, they testify from that chair right there. We call that the witness stand. Witnesses can testify for you or against you. You can ask them questions. We call that either direct examination or cross-examination. Now, you also have a right to waive your right to have witnesses, which means you have a right to give up your right to have witnesses to testify in your case. And by doing so, you will not be calling witnesses to testify. However, the state will be calling witnesses to testify. Now, you also have a right against self-incrimination, which means you have a right not to testify in your case, if you so desire. And you also have a right to waive or give up that right and to testify if you desire to do that. Now, you also have a right to have discovery. Discovery means you have a right to see the state's evidence, the evidence that they have against you. If you would like to see that evidence, the state can allow you to have access to that evidence. They will not be able to, they will not give you any copies, but you'll have access to that evidence, or your attorney will have access to that evidence as well, if you're represented by an attorney. You also have a right to waive or give up your right to have discovery, which means you have a right not to request discovery of the evidence in your case. Now, if you're represented by an attorney, or if you're representing yourself, if you're represented by an attorney, your attorney will have an opportunity to talk to the prosecutors, or if you're representing yourself, you'll have an opportunity to talk to the prosecutors. And the reason why either your attorney or yourself will talk to the prosecutors will be to see if you can work out a settlement on your case. And what a settlement is normally called, it's usually called a plea bargain agreement. You do not have to work out a settlement on your case, but if you do work out a settlement on your case, a plea bargain agreement, if you come to a plea bargain agreement, the court does not have to follow that agreement. If the judge does not follow that agreement that you have made with the state, then you can withdraw, which means you can take back your plea of either guilty or no contest. Now, if the judge does follow the plea bargain agreement that you have entered into with the state, and if you decide within 30 days that you would like to appeal your case, you have to get the court's permission. What an appeal is, you would like to have a higher court look at your case to see whether or not you've been wrongfully convicted, or whether or not this court has committed an error by convicting you. That higher court is actually located right above us. It's called the Ninth Court of Appeals. They will review your case. They could either grant or deny your appeal. If they grant your appeal, then they can simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal your case to another court, to a higher court than the Ninth Court of Appeals. You would have to file a pro se petition for discretionary review. What that means is, pro se means you'll be representing yourself, and you'll be filing that with the Texas Court of Criminal Appeals, which is located in Austin, Texas. It is the highest criminal court in the state of Texas. Now, they could, the Texas Court of Criminal Appeals either could grant or deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty, or they can send the case back down to this court, order this court to give you a whole new trial. If they deny your pro se petition, then your conviction will stand. Now, Jefferson County District Attorney's Office has a program that is called pretrial diversion. Pretrial diversion program is a program that is run by the probation office, but you're not on probation. If you are able to get into the program, your case will be dismissed, and you can get it expunged from your record. And expunction, what that means is you can get it wiped off, deleted, or erased from your record. Now, in order to qualify for that program, it has to be your first offense. It cannot be an offense involving resisting arrest or unlawfully carrying a weapon. And you have to have an attorney to assist you, to help you to get into the program. Okay, they can file the necessary documents or the paperwork. If If you are able to get into the program, as I said, and if you successfully complete the program, the case will be dismissed and you can get it expunged from your record. Now, if you are a veteran of any one of the branches of the United States military, this district attorney's office has a program which is part of the pretrial diversion program that is called Veterans Court. Veterans Court, you get into the Veterans Court program, you complete it, your case is dismissed, you can get it expunged from your record. Now, this court has a program that is called CICE. Excuse me, that is called CSI, the CSI program. The CSI program stands for Community Safety Initiative. Now, that Community Safety Initiative program, I started that program over 4 years ago, soon after I was elected to the bench in this court. The program is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, go to church. And the program basically is designed to address the issue of what we call recidivism, people committing crimes over and over. And now the way it's a pretrial program, usually part of our bond program. The program, we have partnerships with agencies in the community. We have partnership with Spindletop. Now, Spindletop has a mental health and a drug and alcohol abuse program. With the mental health program, we have some individuals who is in court that's going to talk to you later about their program. They can provide private interviews, assessments, a treatment plan, either outpatient or inpatient, for individual mental health needs that need to be addressed. If you have an issue with drugs or alcohol, Spindletop has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery Program, and they can provide interviews, screenings, and outpatient or inpatient treatment placement for individuals who would like to address their alcohol or drug problems. And we also have, you could be sent to what is called OZAR, which is the local the local drug and alcohol council. They can do screenings, treatment plans as well, outpatient or inpatient, and they can help you to get into treatment programs that will best fit your needs. If you are unemployed, or if you want to get employment, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in one of those areas, they will assist you at getting a job in those areas, in the area that you trained in. Also, if you do not have your high school diploma, Lamar University, I think the CICE program has a GED program that can assist you in getting your high school diploma. Now, all of these programs is through this court that I call the CSI program. And I tell people this all the time. When you come to County Court at Law number 2 in Jefferson County, Texas, we don't have court as usual. We have unusual court. And the reason why I say that is not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And we're trying to make a difference in Jefferson County by making Jefferson County a safer place. Also, we're trying to produce productive people. And productive people normally do not commit crimes. And so that's how we are addressing the issue of recidivism. And the other thing is, we do not just arrest the problem, we address the problem. So there are problems that individuals have that are being addressed. And once we address those problems, making Jefferson County a safer place. There's a cycle. The cycle is individuals who do not have an education can't get a job. They can't get a job. They usually turn to drugs and alcohol because they're depressed. And once they turn to drugs and alcohol, they eventually commit a crime. And once they commit a crime, they eventually get caught and do time. And once they do time, they get out. And then they're back into the cycle. They can't get a job. And so it's a cycle. So we're trying to address that cycle. And if we address that cycle, we make Jefferson County a safer place for all to live, work, go to school, raise our children. So that's our community safety initiative. Now, the other thing is that all of these programs that I just spoke of does not cost you 1 cent. They are free. Only thing you have to do is have a desire to be in one of the programs. And the other thing is all of these programs can be used as community service if you have a community service. Now, everyone in here who's here today, you're here because you've been arrested, you're bonded out, and they set you for arraignment. Now, every day that you spent in jail, you can get credit for that towards your sentence, towards your punishment. Every day that you spent in jail also count as $100 per day that can be credited toward your fine and court costs, Deputy Monty. That can be credited toward your fine and court costs. Now, that simply means this. For example, if the state offers you 5 days in jail, you already have 5 days in jail, they'll give you credit you could get credit for time served. Or if they offer you 7, you have 5, the 5 can go toward your 7, and you would only have the 2 days remaining. Now, if they offer you a fine and court costs, say of $500, you did 5 days in jail, that's $500, then you won't have to pay anything extra because the time that you spent in jail has already paid it off, okay? And so, also, if you have been given fine and court costs as part of your punishment, and if you can't pay it off on that day, then we can put you on what is called a payment plan, which means you can pay it off in monthly installments over a period of time. Now, if you cannot pay it off, even if they put you on a payment plan because you don't have the income, then we can convert your fine and court costs to community service, right? And the programs that I just mentioned, if you're in one of those programs, for example, every hour that you spend in community service, $12.50 will go towards your fine and court costs. And then 1 hour will go towards your community service. Now, the program that I just mentioned, the CSI program with the various programs in it, for example, you could do 3 things at one time. For example, if you're getting mental health treatment, while you get every hour of mental health treatment that you're getting, that's 1 hour that goes toward community service and $12.50 that goes towards your fine and court costs. So if you're in job training, the same thing. Every hour you sitting in a job training program, 1 hour is going toward community service and $12.50 is going toward your fine and court costs. So on an 8-hour day, $100 is going toward your fine and court costs. That's what it adds up to. Okay. So I tell people this all the time: you kill 3 birds with 1 stone, which means you're doing one thing, but you're doing 3 things at the same time. Okay. So if you're interested in the programs are free. We have a brochure if you'd like to. You're interested in the CSI program, and we have Miss Misty Lawless, who is from Spindletop. She's going to come up to you, and she's going to come up and tell you something about the Spindletop program. Miss Lawless.
Good morning. As he said, my name is Misty. I'm a qualified mental health professional at Spindletop, and this is my coworker Shelby. And he explained everything very thoroughly. What we're here in the court system for is because what we found is that a lot of people have mental health issues, and they go untreated, and they end up in jail, and they end up in the court. And like he said, it's a vicious cycle. So, Judge Holmes has opened up his court to allow us to come in and to meet with people individually, that may think they have a mental health issue, and has never been diagnosed, or that has been treated previously, but has gone untreated for a while. Because like you said, the recidivism rate, will continue. You will continue to go to jail, you will continue to be in the court system. And that's what we're trying to stop. We want you to be, successful and healthy. And if there's anything that we can do, and if, you don't want to go to Spindletop, or you may have your own doctor, we have other resources. And like you said, we also have resources for alcohol and drug addiction. That's another, common denominator of, what we see of people, in jail and in the court system. And of course, this may not apply to you at all. So we're gonna come around and we're just gonna get some basic information, give you a business card and a brochure, and get, like I said, get some basic information. You may be interested, you may be not. We can also speak with you in the back if, privately. And any information that you give us is completely confidential. Shelby and I will lose our jobs if we provide the information to anyone. We're under strict HIPAA guidelines, unless, of course, that's something that you want to disclose to the judge and to the court. Do you guys have any questions? Okay. So, and when he's finished, we'll just come around, like I said, and get your name and some basic information and give you some information about us. Okay. Thank you very much.
Okay. Thank you, Ms. Lawless.
Yes, sir.
Now, ladies and gentlemen, we're going to have someone to come around. You filled out the information. Make sure you fill out the information on the tablets. And we're going to come around. We're going to have individuals coming around and pick it up. If you need some assistance, they'll be able to assist you as well. And once, it's going to take a few minutes to get all of that done. We're going to put you in various different categories. And then once we get the information, we're going to reconvene. So just be a little patient with us. This should not take that long.